Welcome back to Canadian Justice, where we're discussing self-defense in Canada, and in particular in the context of a home invasion. Now, Karen, we've been talking about proportionality in force and also this notion of reasonable belief about imminent danger as well. So what makes a belief reasonable? Does it have to be a correct belief? For example, if you believe that someone's about to shoot you, but it turns out that they're completely unarmed, would that belief be reasonable?
Well, that's a very interesting question because the law changed in Canada in the 1980s with a series of cases dealing with battered wife syndrome. Mm-hmm. And the court assessed those cases and said, look, even though these men don't appear to be reasonable, given their personal life experience, it's a reasonable belief and a reasonable fear. And these cases really expanded the law of self-defense. And that reasonable belief, that sort of subjective analysis of what are the personal circumstances of the person that's holding that belief, was somewhat removed from these amendments in 2013, which in fact mostly expanded self-defense. But in this one small area, they did actually narrow it a little and say that reasonable belief has to be considered on a number of objective factors. But in practice, juries consider the personal circumstances of the accused, and they acquit if they think, under those circumstances, if I was that person, I would have had a reasonable belief. So the fact that the person turns out to be unarmed is not fatal to availing yourself of self-defense.
Now, Lisa, one of the other things we've been talking about is the notion of proportionality of force. For example, if someone attacks you unarmed, would you still be able to make a claim of self-defense if you defended yourself with a weapon?
In principle, yes. There's no rule, for example, that if somebody is attacking me unarmed and I'm holding a knife, that I'm required to throw the knife out of reach to make it a fair combat. You can see that that would be unreasonable in the sense that, after all, I'm the one who's being attacked. So I should be allowed to reasonably defend myself in whatever way I can. And as Karen mentioned earlier, there's this long-held idea in the common law system that no one is required to weigh to a nicety the use of force in a self-defense situation. So nobody is required to use exactly the precise quantum of force that is proportionate to whatever they're facing. Nevertheless, proportionality is listed among a number of other factors in the criminal code as something to be considered when considering whether the self-defensive force is reasonable. And no doubt there are situations where the amount of force being used relative to the threat is so extreme that that's a reason to say this use of force wasn't reasonable. Self-defense is not available.
Now, Karen, I want to let you respond to that as well, but I also want to ask this question about exhausting alternatives. Do you need to exhaust alternatives if you're going to claim self-defense? For example, is there a requirement that you back down or run away and escape or hide before? And if you didn't do that, and how reasonable is it for you to claim self-defense then? And would a claim like that succeed if you could have perhaps escaped but didn't?
Well, that's very interesting because the previous law prior to 2013 had a duty to retreat. And also it contained a provision that you couldn't be the initial aggressor. And this is why I say, in general, the 2013 amendments expanded self-defense. They were very welcomed by criminal defense lawyers. We're very pleased with them. And in general, they expanded self-defense. The duty to retreat was a judge-made, sort of a soft judge-made requirement, and they almost always required it. The new provisions, because they're so explicitly written, don't include a duty to retreat. It's a consideration, but it's not a duty. And they also don't include the requirement that the person claiming self-defense not be the initial aggressor. They can be the initial aggressor. And so in that sense, those amendments were very welcome. The removal of this sort of the clear subjective consideration of the accused narrowed it in that sense. But generally, it did broaden it a little bit. They were very welcome amendments by criminal defense lawyers.
Lisa, is there anything you want to add to that?
No, I agree. The legislation actually uses the phrase whether there were other means available to respond to the potential threat, right? So that's the question that a jury would have to ask themselves, whether there were other means available and whether the fact that retreat was available, for example, as an option in the circumstances might have made the use of force unreasonable.
We've got to go to commercial break now, but when we come back, I want to ask you both about and yet another comparison to the United States, which has very robust self-defense laws, and in particular, a kind of law in the U.S. called a stand your ground law. We'll be right back.